tell me when I can. Okay. Good afternoon. This open meeting of the Board of Appeals for the Town of Nantucket is being conducted remotely or hybrid pursuant to Chapter 2 of the Acts of 2023. Ensuring public access does not ensure public participation unless such participation is required by law. This meeting will feature public comment. For this meeting, the Town of Nantucket Board of Appeals is convening by video conference via the Zoom app and in person, as posted on the town's website, identifying how the public may join. Please note that some attendees may be participating by video conference. Accordingly, be aware that other folks may be able to see you. Also, take care not to screen share your computer. All supporting materials that have been provided members of this body are available on the town's website unless otherwise noted. The public is encouraged to follow along using the posted agenda unless the chair notes otherwise. Okay, the chair can request that members of the public provide their names for purposes of keeping accurate minutes of the meeting. Attendees will join in listening mode. They can click the raise hand button if they wish to speak. The chair will call on those who have raised their hands in the order they were raised to the best of our ability to do that. All questions should be directed through the chair. My name is Susan McCarthy. I'm the current sitting chair of the Board of Appeals. Please permit me to confirm that all members and persons anticipated on the agenda are present and can hear me. Members, when I call your name, please respond in the affirmative. John Brusher.
Here.
Michael O'Mara.
Here.
Elisa Allen.
Here.
Joe Marklinger.
Here.
Alternate member Jim Mondani.
Here.
Alternate member Lisa Botticelli.
Here.
And Mark Poor is going to be late. We'll just note when he shows up. Okay. Staff, when I call your name, please respond in the affirmative. Billy Saad.
Here.
And I think that's it in the audience. Anticipated speakers on the agenda, please respond in the affirmative. Attorney Pucci. Okay. Attorney Pickering-Cook.
Here.
And Attorney Hoffman. Oh, McLaughlin, sorry. Okay, great. Thank you. Okay. So I will now open the special meeting of the Town of Nantucket Board of Appeals, Monday, June 3rd, 2024, 1:06 p.m. Would someone make a motion to approve the agenda as drafted?
So moved.
Second.
John Brusher makes that motion. Elisa Allen seconds. I'll do roll call vote. John Brusher.
Aye.
Elisa Allen.
Aye.
Michael O'Mara.
Aye.
Myself, aye, and Joe Marklinger.
Aye.
Okay. Moving on to section 3 of the agenda. So we have a public comment section. This section is for items not listed on the agenda. So if you are in the audience or online and you want to speak about the remand hearing, that will come later. If you have something else for public comment that is not related to the topic of the matter before us today, then this is the time for you to make that comment. Is there anyone in the audience who had an item for public comment that's for an item not anticipated on the agenda? Okay. Just if you can identify yourself.
Sorry.
That's okay, no problem. Is there anyone online that has their hand up for a public comment?
No, there are no hands online.
Okay. So we can move straight to old business. This is going to be application 1124, Cathy Ward as applicant, 9 West Dover Street. Attorney Pickering-Cook is representing the applicant. Before you go speak, Nina, I was going to ask Attorney Pucci if he could just give the board a recap for and for the audience too, a recap of what's before the board, what was decided, and what we're looking at in this remand hearing. Thank you, George.
Good afternoon, Madam Chair and members of the board. I am George Pucci from KP Law, Nantucket Town Council. I'm here as counsel to the board. If you have any questions or comments that you would like to have reviewed by council, that's what I'm here for. So you can raise those during your hearing process or save them, submit them later, however you want. I'm here to advise you as needed. I'm going to speak for as little as possible at the beginning here because it's going to be, you're going to be receiving quite a bit of information both from the Wards Council as well as the Grapes Council who are here today. And also I'm sure you'll hear from interested parties and the public on the issue of short-term rentals and accessory use of primary dwellings. And again, I'm available to provide you more detail if you want it, but I'm going to start out with just the bare bone of why you're here today. So you're conducting a public hearing. It's ordered on remand from the land court judge who heard the lawsuit of the Wards against Ms. Ward against the Grapes. Both the town and the ZBA were also parties to that lawsuit. As a result of that lawsuit, the judge of the land court issued this remand order to the board to reconsider the original decision, which upheld the building commissioner's determination not to take enforcement against the Grapes for short-term rentals at their property. And that property is at 9 West Dover Street. You're not here to legislate for the island or address this as a general matter. What we're talking about is a fact-specific matter, the manner in which the Grapes are renting their property that's in the ROH district. And the court sent it back to you. He disagreed with the board's original finding that the use was a principal use of a primary dwelling in the ROH district. But what he did was send it back to you to reconsider your decision, and specifically on the last page. While the court will vacate the ZBA decision and declare that short-term rentals aren't allowed as a principal use of primary dwellings in Nantucket's ROH district, the court will remand the case to the ZBA so that it can determine whether the Grapes' rental of their main house are a permissible accessory use of that structure, and if not, order the appropriate remedies. So that's the question that is before you in the remand hearing. You're going to hear from the Wards Council, urging you to take a certain position on that issue. You're going to hear from the Grapes Council, presenting their side of it. And you'll also open up to third parties and public comment. Obviously, the board members may have questions or comments. You should feel free to ask questions as the proceeding goes forward, of parties presenting any information to you, and also to keep it amongst the board for your own discussions about this issue. So again, what you're doing is you're interpreting your own zoning bylaw, but limited to the issue of whether the Grapes' rental of their property is an accessory use of their primary dwelling on that property on 9 West Dover Street. I want to remind you of one principle that's pretty important, is the zoning board is entitled to deference of its interpretation of the meaning of provisions in your zoning bylaw. So as part of this process, you're going to want to take in whatever information you find relevant to that issue, and then you're going to interpret your zoning bylaw on this issue of accessory use. And then ultimately, you're going to render a decision in accordance with the court's order. That's going to be sent back to the court at some point. Probably one party or the other is going to be not thrilled about your decision, because it, is kind of zero-sum game, really, in terms of if the wards want to have the Grapes cease and desist what they're doing at 9 West Dover Street. So, the matter is obviously very high stakes to the parties that are involved. But again, you're the board entitled to deference with regard to interpretation of your zoning bylaw provisions. And one last thing I'll say is, in addition to the presentations that you'll get from the plaintiff and co-defendants in the lawsuit, you're also entitled to hear evidence concerning customary practices on Nantucket, specifically with reference to a case that came from the state's highest court, the Supreme Judicial Court, in the Stiller versus Linfield case. And in that case, there was a footnote that the judge was specifically applying in this case as to whether in this particular community, short-term rentals of a primary residence are incidental and customary in that community in question. So if you have any questions, concerning the standards as we go along, feel free to ask them. But I would recommend that you kind of sit back, employ a beginner's mind to the presentations that are going to be made, and you'll have plenty of time to interpret your zoning bylaw and ask any questions and discuss it amongst yourselves for the best decision that you can come up with. Counsel will be available to assist you in drafting the decision, when you're at that point. So thank you.
Okay, thank you, George. So just for everyone's, manage everyone's expectations. So how I see this going is we're gonna have the applicant, which is Ward, and through Attorney Pickering-Cook, make their presentation. Then we'll go to the Grapes Council to make their presentation. We'll see where we are for time then, maybe take a break. Board can ask some questions if we have questions at that point. And I really am going to stress today and going forward with all of these hearings that we really do questions through me to whoever they're going to, so we don't have talking over, and we keep it streamlined, especially for the minutes, because I don't know what will happen after we get through all this and make a decision, but there may be an appeal, so the minutes are going to be very important. So I want really everyone to focus on following the procedure that we really should follow all the time. And people who are in the audience who are speaking, if you can please remember to identify yourself and speak clearly and slowly for taking minutes. That would be a very big help. And then we will get to public comment. We'll see where we are after both the applicant and the appellant make their presentations, when both sides make their presentations. But I just want everyone to know you will have an opportunity to speak. This is most likely going to take a couple hearings, and the public comment is an important part of that. So just be patient with us, and we will do the best we can to get to everyone. I see, oh, sorry, did you need me to speak louder? Okay, I'll take my own advice. Thank you. All right, so we'll start with you, Attorney Pickering-Cook. You have the floor.
Great, thank you, Madam Chair, and good afternoon, members of the board. Nina Pickering-Cook of Anderson and Krieger. I represent Cathy Ward, who is with me here today. I had previously submitted a legal memo to Town Council that I believe was forwarded to the board last week. For your use in the hearing today, I do have a one-page handout. With some relevant language for the board to look at.
No. Do you have one more, Nina?
Yep, I have more if you
Yeah.
need more.
Jim didn't get one.
Yep.
I got it, yes.
Thank you.
So I think, George, for the start, that was where I was going to start as far as orienting the board to what you're doing here today. You are looking at a fairly narrow issue of on remand for the court as to whether the grapes use as set forth in the case is a legitimate accessory use under the Nantucket bylaw. Now, that is the only issue before you. I know there's lots of focus on this issue throughout the island. And although your decision may well be instructive for other cases, today you are only looking at the facts of 9 West Overstreet. I think George and I agree on that point. The only thing I'm going to disagree with what George said is I don't necessarily believe that this is a zero-sum game here. I do think that there is a resolution in front of this board that would allow the Grapes to continue renting to some extent in a way that would be compliant with the zoning bylaw. So I will explain how I get there. First of all, in order to figure out whether this is a lawful accessory use, you of course need to understand what an accessory use is. And the Nantucket zoning bylaw defines the accessory use in section 139-15. You have that in front of you, that language in front of you. It's a use that is subordinate and customarily incident to the permissible principal use. So the important thing here is you must satisfy both of those characteristics in order to be a legitimate accessory use. You heard Mr. Pucci reference whether part of your job is going to be looking at whether short-term rentals are customarily incidental to a residential use on Nantucket. That's only one prong. You also need to find that it is subordinate to a principal use. Now, the case law has defined subordinate as less than or of a lower rank or a lower use amount of use. That's what the Massachusetts cases have determined to be the definition of subordinate when it comes to a zoning use. So in order to be an accessory use, it has to be both subordinate and customarily incidental to a principal use. The Grapes short-term rental use, as found by the court, fails on both of those prongs, and I'll explain why. So the first prong is that it must be subordinate, meaning less than an allowed use. Now, the court has found the relevant facts for you here, okay? The court has already set forth in its decision the number of days that the Grapes from 2017 to 2021 used their house as a rental and the number of days that they personally occupied it on an annual basis. The zoning board is bound, as George will tell you, to the findings of fact that the court has already made in this case. And those findings are that the Grapes used their house for short-term rentals more often than they used it for personal stays. From 2017 to 2021, they used the main house for rentals between 90 and 111 days per year, and they occupied it personally for 40 to 55 days per year. So the rental use of 9 West Overstreet nearly doubled the residential use. Now I want to address the issue of the days that the house are vacant. You'll surely hear from Mr. Hoffman and Mr. McLaughlin that the days that the house are vacant should be counted towards that personal residential use. But there are 3 reasons why the ZBA should reject that argument. Number 1 is that the judge has already considered and rejected that argument. This is not the first time we're hearing this from the Grapes Council. Judge Vey noted the number of days that the property sat vacant, meaning not in use, in his decision, and he explicitly did not count them towards the analysis of the property's use. Accordingly, the board should not consider those days the house sat vacant either as a residential use or a rental use. He would have found for the Grapes' use as a residence was a principal use if he had counted the vacant days, but he ruled the opposite. So if the ZBA counts the vacant days contrary to the judge's decision, I fear you are going to be subject to more litigation. Now, the second reason is that the number of days that the Grapes used the house, meaning the 40 to 55 days per year, this is not a made-up number, right? This is a number that is taken directly from the Grapes' tax returns. In the IRS schedule for accounting and deducting expenses for investment property, the Grapes have self-reported the number of days they use the house versus when they rent the house. So they cannot ignore the number. And so to be clear, the number of days they said on their tax returns, they used the house was 40 to 55 days, in that range. They did not count vacant days on their tax returns. They cannot ignore vacancy days for tax purposes and then ask the town to count those vacancy days for zoning purposes. That brings up the old adage of you can't have it both ways, certainly with respect to your filings with governmental entities. Now, one could also argue that the days it is vacant, it is also available for rent for all of those days. If you go online, you'll see that there's a calendar and you can click on any week of the year in order to request to rent the house. So it is available to rent for all of those vacant days. Now, the third point in rebutting this vacancy argument is that use really has to mean use of the property, right? We agree that the grapes can come and go as much as they want. A lot of the argument you will hear on the vacancy is that the house is available for them to use during those vacant times. We completely agree with that. It is well within the control to use their house as opposed to the garage for their residential use whenever they want. But in order for them to rent their property, they just need to ensure that their use of the main house is more than the days that they rent it. So although this has not been the case for the grapes in the past, if you just heard their rental use outweighs their personal residential use. If they want to go forward with renting the grapes, it would be permitted as an accessory use if the grapes use their property personally more than they rent it. Now, and that's wholly within their control, right? They have stated as much. They've represented to you that they'll be using the house more now that they're both entering retirement. And if they did so, they would just need to use that property more than they rent it in order for it to be deemed an accessory use. This is a clear line that the ZBA can establish and determine and enforce. I would also note that with respect to the vacancy issue, the number of vacant days, the number of days a rental sits vacant does have an impact on the neighborhood, right? You have, if the ZBA counts the vacancy days as the grapes want, then you have to understand that that will be seen by full-time short-term rentals, those houses that are exclusively short-term rentals with no residential use in them would be deemed a lawful accessory use if the owner can count vacant days as residential use, right? You could have an exclusive STR that's rented for 3 months a day and vacant for 9 months. And under the grapes argument, that would still be an accessory use, although the only actual use of the property is as a rental for 3 months of the year. So again, the use has to mean the use here. Now, maybe that's exactly what the Grapes Council wants. The Grapes Council is also counsel for the Copley Group, and it makes, it certainly would behoove the Copley Group to have an accessory use decision from this board that renders their use now permissible as well. But that's makes no sense under the law of this case in front of you, nor does it make sense under your definitions under the bylaw. Now, the other prong that I will just touch on quickly is whether the short-term rental use is customarily incidental to the residential use. Here on Nantucket, you will hear lots that Nantucket is not Linfield, right? The Styler case is out of Linfield. Linfield is a metro Boston suburb that has a little in common with Nantucket. However, they do share a zoning bylaw that is written fairly similarly. But what I will tell you is even under this prong of customarily incidental, a property that is used more as a rental than as a residence itself is not the customary historical rental use on Nantucket. Now, I don't need to stand up here and harp on this point. I think you all as islanders are going to understand this a lot better than I do, right? My understanding is that in the past decade, STR use has exploded with the advent of platforms like Airbnb and VRBO and other online listings that are driving short-term rentals as investment vehicles. The current use of STRs as investment properties is not the same, as I understand it, as the traditional renting that was done on the island to defray expenses by both residents and seasonal owners. I believe you'll hear public comment on this point. But the use for rental as the use of a property as a rental for the vast majority of its time as an investment vehicle is not the customary use of a rental on Nantucket. That is a new use that has exploded in the last 10 years. So with that, I will just say, because the Grape's past use, and again, we're looking at the facts as the court found them, because the Grape's past use of 9 West Dover Street is neither subordinate nor customarily incidental to their residential use of the property as an owner, it's not allowed as an accessory use. I would note that if that behavior changes going forward, then perhaps it could be deemed an accessory use if there are some limitations put on the rental versus the residential use. With that, I'm happy to answer any questions the board may have.
Joe, you have a question for Attorney Cook?
So if they were to live there 270 days a year and rent it out 90 days a year, would you then consider that accessory?
Yes, I think that would be both, again, if the 270 was actual residential use of the property, yes.
So if it was on their income tax return, if they would have put 270 down instead of
40 to 50.
40 to
yeah.
55?
Yes. That would be that would be subordinate, and I think that extent of use would be in line with what I understand to be the customary use of rentals on Nantucket. So it meets both of those prongs.
So if they had their children stay there, family members?
Yep.
Different time?
That's
that
not
would count?
renting, that's not a commercial investment property.
Okay. Thank you.
Yep. Anything else?
I do, Madam Chair.
Okay,
So
Jim?
using Joe's example, the 270, without it being on some IRS form, how do you characterize the 270 days, their use?
I'm not sure I understand your question. How do I they would have to use the property as a residence for 270 days or as
And what
for
do you
friends
call
and family.
resident? Like, what is a residence? They have to live there, actually physically live there?
It doesn't have to be the Grapes personally, any long-term residential use. So they could rent it on a long-term basis for 270 days. That's residential use. It's not saying they personally need to be physically in the house. It's just saying the house needs to be used as a residence. And the court has determined that using it for a short-term rental is not residential use.
Hold on. Jim, does that?
Yeah.
Okay. Elisa?
Did you just say that short-term rentals just took off in the last 10 years?
I said there has been an explosion of short-term rentals in the last 10 years.
There's been an explosion.
That is my understanding.
What do you mean explosion?
I mean, I believe this data that I've seen that we presented in the case is that the number of nightly rentals available on the island has gone up 10 or 20-fold.
Nightly rentals,
Correct.
not short-term rentals.
Nightly rentals short-term rentals are counted in the data based on nightly rentals.
Thank you.
And I'm happy if that's helpful, I can certainly give you guys that data.
Any other questions for Attorney Cook at this point? No. Okay, so we can move on to Attorney McLaughlin.
Good afternoon, Madam Chair, members of the Zoning Board of Appeals. I am Attorney Robert McLaughlin, firm of Gilman, McLaughlin, and in Boston.
I think you're gonna, can we make sure that microphone's on, Billy? Okay,
How's that? I don't want to swallow
better,
it.
that's great.
So, I represent Linda and Peter Grape, and they're the owners of course, as you know, 9 West Dover Street. We all understand this case is here to you on a remand. I want to emphasize that the court held that you never considered accessory use, and the concept that you are limited because the judge found that in determining what was a primary use, that you would not consider vacant use is absolutely incorrect. You didn't deal with accessory use at all, and that's why you're here today. And you absolutely can consider, and I'll get into why vacancy is absolutely to be counted towards primary use. So let me go on and say, when Judge Vey remanded this case, and what he said is very informative. What he said was, if short-term rentals are customarily incidental to using primary dwellings in Nantucket, after all, Ward admitted at trial of being both a short-term lessor and short-term renter of the Nantucket residence. The bylaw, so if it's customary, the bylaw allows some level of rental, of level rentals. Much of what Judge Vey relied upon was the Stello decision, which has been referred to, and the infamous footnote 19, and I'll read it all to you because it's very important. That a different result may obtain under the specifics of other town bylaws, as well as what is considered customarily accessory use in a particular community. Judge Vey did not retain jurisdiction. The Quick case, which is Quick and Keefe, I think it is also before you. He did specifically retain jurisdiction. And I heard town council say that maybe this will go back to the court. I hope it doesn't go back to the court. Hope you make such a logical and effective and fair decision that is given great deference that neither side wants to take it back to the court. I think he gave you substantial latitude. I've already addressed the fact that you absolutely have the latitude to consider the vacant use, which is a central issue in this case. So, now the Nantucket zoning bylaw defines accessory use as, you've heard it, but I'm going to repeat it again. 3 words: subordinate, customarily, and incidental to the principal use on the same lot. It goes on and it says, section 139.15 continues, such activities shall be allowed if they are subordinate, customarily, and incidental to such permitted use. Those 3 words are your guardrails. I'm going to spend a few minutes and go through those three words. Subordinate. How do we determine what is subordinate? Well, you have 2 uses. You don't have like a use which is primary and the person's raising chickens in the back door. You get the backyard. You got 2 uses that are exactly the same. So how are they different? One's long, one's short. How do you analyze that? How many days? So we're talking about days, all right? Now, I say it makes sense to compare the number of days the Grapes rent the property to short-term renters versus the primary use as their vacation home. That's the primary use, their vacation home. It is impossible to do what my sister has just suggested. She says you must compare the number of days that the people live in their own home and the number of days they lived in for an equivalent minus 1 day they can rent it out. Well, there are 1,700 rental units that are registered. So who's going to go around and determine who's lived how many days in each of the 1,700? It's an unworkable solution. As a matter of fact, today is June 3rd, and the Grapes haven't rented their house yet. How are you going to determine how many more days are they going to use it? It may sound good, and it's the only basis upon which she can make an argument that accessory use is limited by comparing rental with primary use, but it doesn't work, and you're not bound by it. And indeed, there are, well, let me get to that in a minute. We all agree, 90 days to 111 days. Linda Grape is going to testify. The 111 days is the year in 2017. None of us are that old. I'm old, but I don't remember 1917. She's going to testify that that's the year they bought the place, and they inherited it from the prior owner who had rented it that summer already on their behalf that they had to recognize for the 111 days. So, in any event, what 90 to 100 days means that there are 254 to 275 days that this property is being used as the primary vacation home of the Grapes. That analysis is well supported, not only by law, but by common sense. Nantucket has a zoning bylaw that says a dwelling unit is a room or enclosed floor space used or to be used as a habitable unit for one family or household with facilities, sleeping, cooking, and sanitation. And the irony of everything here today is Judge Vey, interpreting the Nantucket bylaw, dealt with a situation of somebody who was looking to take a shack that had been deserted for over 10 years and applied for a special permit that the non-conforming use can be expanded. And the neighbor said, well, you abandoned that. 3 years and you're out. Judge Vey, focusing on those exact same words, used or to be used, said no. It still had a kitchen falling apart. It still had a bathroom falling apart. It still had a bedroom falling apart. But it was there to be used as residential use. It was not abandoned. That is a compelling precedent that the law says that the 275 days that maybe this grape property is vacant, it to be used for the primary purpose, which is the grape vacation home. That's the central issue in this case. Continuing, there's another case, as a matter of fact, in which the language, not in Nantucket, but says if the property is designed for habitable use, you don't have to show that it was being occupied. So that case that I just referred to you is Maldon versus McCarthy. That's the falling apart shack that was still being held for primary use. Beyond that, common sense. You look at the Linda Grape affidavit. She says that in the cold months, and I assume she's going to testify to this too, they come down once or twice a month. In the warmer months, 3 times. They come down traditionally over Thanksgiving weekends. They come down for family celebrations. They come down, their family members pop down when it's convenient to them. In retirement, they expect to spend more time. Dr. Grape's already retired. Linda hopefully soon will be, and they'll be here a lot more. During the summer, they're here 3-4 weeks. Spur of the moment, the weather looks good, let's go away for a Nantucket weekend. That's what a vacation home is, all year long. A place you can pop down to, you come to, you pay the taxes on and the maintenance, it's your vacation home. That's the primary use. And now we compare that with the accessory use. They have complete control over it. As a matter of fact, the 111 days, 90 days to 111 days, 90 days is 24.6%, except leap year, it's a little bit less, and 30.4% when we're talking 111 days. And it makes that sense because why are we here? We're here because Ms. Ward had some complaints about light and air. Well, she has no complaints about night and air when it's vacant. So why should she get credit as a short-term renter? That when it's vacant, you don't compare that. Well, you do compare that. She has as quiet as a mouse during the times that it's vacant. So, well, all right. I think I have covered subordinate. Let me move on to the second word, incidental. Incidental. Our brief cites the case of Town of Harvard versus Maxton, where it defines accessory as when used to define accessory use, incidental must be incorporated with the concept of a reasonable relationship with the primary use and must be attendant and concomitant. Now, to me, that means if you have a single-family zone and someone wants to put a commercial use there, it's not incidental, it's not concomitant. You cannot be any more concomitant and incidental than using exactly the same use, except it's a little bit shorter. So incidental, it's crystal clear in spades. So we come to the third issue, which is customarily. And like Ms. Nina Cook, it's not for me, because I guess you call them off-islanders, to tell you what is customarily. I expect you'll hear testimony from your neighbors. It is you, and you're sitting on this board because you have the pulse and the actual knowledge of Nantucket. But let me point out to you the written record, because I can refer that to you even as an off-islander. Exhibit 2 in our submission is the purpose clause of the short-term rental group that works so hard and has yet to find success for the happy medium or the compromise that'll solve this cultural problem, maybe. But their bylaw says, purpose, to protect the time-honored tradition. Well, I don't know of a better definition of customarily, of home rentals on Nantucket and preserve economic opportunity for persons to keep their homes now and into the future, and through short-term rentals to allow such persons to afford to live either full-time or part-time. And the second impact, and I won't quote the whole thing, but it's the obvious adverse impact of the local economy. I also refer, and it's Exhibit 3 of the UMass Amherst Donahue report and so forth. And I hope you consider the whole report that has to do with the economic impact. But what I call to your attention is 9 out of 10 of the tourist rooms are serviced by short-term rentals. You made the same conclusion in the 14 New Mill Street case, where Nantucket has been and continues to be a popular destination. Rentals of private properties contribute to the health of the local economy in a myriad of ways, so forth. Miss Penny Day submitted a letter to you, and I certainly don't want to steal her thunder, but I do want to call attention to one of the paragraphs in her letter. In 1980, and I was alive then, Nantucket made a policy decision. We're not going to become high-rise Miami-type destination hotels. It's been limited. We'll service our industry and preserve the charm of Nantucket with the single-family houses. Lisa Wynn has filed a letter with you, and I hope you hear from her. Ed Sanford could not, but he submitted a letter. Now, here's where I think we have a decision to make, or a distinction. And I think I agree with town council. You are not a policy-making board, and Ms. Cook is asking you to become a policy-making board. You start deciding, you make policy, you can use it as much as you can rent it as much as you use it, or maybe you're going to set how many days or how much turnover. That's not your job. What's before you, up or down, yes or no, the Grapes have used 90 to 111 days. Is that those same 3 words, subordinate, customarily incidental? The answer is overwhelmingly yes, up or down. I don't think you can go anywhere in between. The decision of Judge Bay says, remanded to you, and it will be developed. It'll be developed like case law is developed. As people come back before you, and I'm afraid they may, the way Judge Bay has left this, as they do, I submit you are well within your rights to be able to say 182 days, leap year or not, it's still 182 days, is subordinate and incidental and customarily. But you don't go there. You're only asked to say that the grapes, when they use the property for that 90 to 111 days, were well within their rights to do so because they've touched those three bases. So that I will. I want to point out one twist, which is unique, not entirely unique, to the grapes. They have a garage that has a full apartment unit above the garage. So they have two independent living units. And they're there much of the time when the place is also rented. As a matter of fact, you don't have the numbers before you, but you may hear from the grapes that in some years, they probably, if you count the time they're there staying in the garage while the main house is being rented, they probably do exceed the amount. But the point is, if they're both there, the short-term rental and they're there, why do the short-term rental people get to count the whole day? Maybe they should only get to count a half day, but that's a nuance, and I'm not so sure that's for you. I'm asking up or down. The grapes properly rented their place for up to 111 days, and they may continue to do so. Thank you very much. Oh, yes, any questions?
Joe?
Yeah. So on the vacant days, is there like a calendar that they're marked vacant?
No.
So this is just.
That's the very purpose why it's a vacation.
No, I didn't finish my question.
I'm
yet.
sorry.
It's okay. So, well, I guess I'm going to make a statement. So it seems to me if there's not a calendar, those vacant days are available for the owner or for the short-term rental. We don't know which it is because it's not defined.
I think you're right. I think if someone wanted to rent it, to come to the Christmas walk.
Yeah.
But the point is, they're sitting up there in Wellesley and they say, let's go to the Christmas walk ourselves this year. The point is, it's held for their use as a vacational program. Let me.
No, we don't know. You don't know. You just said there isn't a calendar. It doesn't say on a calendar reserved for owners.
When it's, no, I agree with you. It doesn't say, that's, my house is.
So to me, that's a state of limbo. It's neither reserved for the owners nor reserved for the short-term rental people.
But that doesn't have to be in writing when you're the owner, sir. When you're the owner, you don't have to write down, I reserve it for myself. You only don't have it when you've entered into a lease.
When you rent through Airbnb, isn't there some kind of mechanism that
They don't rent.
you make it available on certain days? I don't know. I have no idea.
Well, they don't rent through Airbnb, but the point is, are you saying?
Don't you tell the broker that it's going to be available all summer long, but not, the rest of the year?
And sir, who makes that decision? The owner makes that decision. Gee, we're taking 2 weeks in August this year, so let's rent it the rest of it.
So the rest of the people don't, I don't want to argue over it, but to me, it's like you don't know what the vacant days, how they're going to be used. It is up to the owner to decide, but the rest of the world doesn't know.
In advance, no, they don't know. No. Now,
Wait, I wanted to ask another question.
Pardon me?
I wanted to ask another question.
Can I add one other point on that question?
Sure.
I heard Ms. Cook starting getting involved in the nuances of the income tax return of the grapes, which I urge you, don't go there. You're getting into the nuances of how much of a depreciation, which lowers their basis when they sell it, should they take each year. That is a rat hole. Don't go down that. And it's irrelevant to what you're dealing with today. Can I have your second question, sir?
It's just, generally speaking, that rented short-term through the main season, through the summer.
Not entirely.
100%.
They're there 3 or 4 weeks during the summer themselves.
Oh, okay.
Yeah, absolutely.
All right, thank you.
And expect to be more.
Madam Chair.
Yes, Elisa?
I think the point was just made that it's such a gray area, but the decision is up to the homeowners. It's not in stone how many days they're going to use it or how many days they're not going to use it from January 1st. It's a loose schedule depending on if they get renters or if they don't. Therefore, this isn't an exact science and it's hard to monitor and it's hard to equate. But ultimately, they're private homeowners that make that decision as the weeks and days of the year go on. Is that right?
It's not an exact science. It is the definition of what a vacation home is. It's entirely up to the owner. And that's the primary use. Vacation home, we'll use it when we want to, except when we rent it, which is subordinate, customarily, and incidental.
Susan?
Lisa?
But under that definition, if it's available on all those other days, how can you count those vacated days towards use?
It's not
To
available
primary
on
use.
those. It's their decision, not written down. They're not actively trying to rent it in January, February, March, April, May. It's just their decision when they want to come down.
I understand that, I'm just saying, but
But-
if it is available on a calendar,
But I-
it needs to be used towards one count or the other. And in my opinion, it would be used more towards not have, so hold on, I'm just losing my train of thought. That those, if it's available, it is being used towards the short-term rental equation.
I also come back to what this is all about. When it's vacant, it's quiet as a mouse.
I think
That.
Sorry.
I'm sorry.
I was just going to, I think that the question you asked, and that's going to end up being discussion among the board of how we come down on it. I mean, it's pretty clear how Attorney Cook's argument is on the vacant days, Attorney McLaughlin's argument is on the vacant days, and it's going to be up to us to hash that out at some point. Did you have a comment?
Yeah, Madam Chair, if I could just clarify the record for you. With respect to the issue of the calendar and the vacant days, this is an issue that was discussed and findings of fact were made by the judge. So I encourage you, through your lawyer, to take a look at those findings of fact. What you will see in there is that there are specific findings that the Grapes used 3 separate rental agencies. Those rental agencies maintained online calendars. On those online calendars, the Grapes had blacked out the dates that they wanted to reserve for their personal use. All the other dates on those calendars, including January, February, and March, are all available for rent. 365 days a year, minus the days that the Grapes had carved out for themselves. That's a finding of fact that the judge has already made in this case.
And if I only may respond to anything, the one thing we all know for sure is what the judge said. This board has never considered accessory use. That finding might have a lot to do with what is primary use, has nothing to do with what is accessory use. Can I yield, if I'm done with questions, to the actual appellee, which is Linda Grape?
Of course.
Like to,
Of course.
And unless there's no more questions,
Can I just have one question,
Okay,
sorry.
Jim, no, don't be sorry.
And either can answer this, but this is an extreme example, but, and I don't even know why we use a year. It should be calculated based on their whole time of ownership. But if they didn't use the property at all during the year and they rented one day, is that 100%? Or is that 1/365th?
I'm not sure I understand what you're saying. If I owned a piece of property and didn't use it at all, and then decided the next year, I'm going to rent it out during the summer season, I think I
Just
got
one
that.
day? Is that 100%?
The one day
Is that
I use it or rented it one day. I suppose it's just, if I understand your question, to rent it one day, that's a short-term rental. And you couldn't do it if you accept what
Well, it kind of goes against what you're saying,
But-
because I think that the other days, they don't actually have to use it.
They don't have to. That's what to be used in your zoning bylaw, and that's what Judge Vay found. You don't have to be there. That's the law of your zoning code.
Yeah.
Oh. Well, then maybe I did.
Right.
Go ahead.
Yeah, sure, just
John
if you-
Hoffman.
hold on,
Here in Nantucket
Okay,
for
so
some
if
reason.
Attorney Hoffman, correct?
Yes.
Can you want to go to the microphone and,
Yeah, no, go ahead.
okay. Well, he was going to yield his time. Sorry, he wasn't yielding to you, my fault.
Sorry, I
I
didn't,
think he just misunderstood the question.
yeah.
You're saying an example is the Grapes own the property. They don't use it that year for whatever reason.
They're not
It's
physically-
vacant for 364 days. They rent it for 1 day. What does that mean? Under Attorney Pickering-Cook's analysis, that would mean it's improper because 1 is greater than 0.
It's 100%.
But I think your question is, which we are saying, and to clarify any confusion, they own it. They don't necessarily have to use it 200, 300 days a year. And we would say, even in that circumstance, the potential use as their vacation home outweighs 1 rental day.
And I think we actually agree on that point. The only distinction I would make is whether the other 364 days, the property was available for rent and advertised on a website.
Okay. And that's what I'm getting at. What happens with the 364 days? How do you characterize it?
Okay. Attorney McLaughlin, did you still want to?
I would like to
let
yield to
Mrs.
Linda Grape unless
Sure.
anyone has any more questions. I'm here
Does anyone have any more questions for Attorney McLaughlin at this point? No, okay,
and I'm
so,
available for questions.
okay, so Mrs. Grape, if you can just identify yourself for the minutes, you have the floor.
Certainly. Can you hear me okay?
Yes.
Thank you. My name is Linda Oliver Grape, and my husband and I own the property on 9 Westover Road. I have some prepared comments, and I also want to follow up on some things that have just been said, if I may. As I said, we've owned the property at 9 Westover since March of 2017 and consider it our vacation home. While we are residents of Wellesley, where I am the vice chair of the Board of Health and a 25-year member of town meeting, which is a representative town meeting, Nantucket has been and will continue to be our second home and our, air quote, go-to anytime that we are able. We first came to Nantucket for our honeymoon over 40 years ago. I won't get into specifics, but it's been a long time that we've been coming, and we fell in love with the island. Since then, we've been back at least annually for 10 to 21 days and many years, multiple times. We initially rented in Codfish Park in Sconset and eventually landed on Pochek Street in Sconset, where we rented one home and then for the 1 year and then for the next 20 plus years, and from 1988 to 2013, another home on Pochek Street in Sconset. We were given the right of first refusal to purchase that home that we had rented for decades when it went on the market in September of 2011. But with a child in college and another one in business school, it was not the time. Fortunately, it happened for a reason. Our youngest child was killed a few weeks later. And after going back to the home for 2 years with the assistance and support of friends, we ultimately decided as a family it was too painful, and we tried renting in town instead. The town worked for our family. We enjoy, if you will, the town being a year-round opportunity, more 3-season than 4, but we still come in the winter regularly. We like the proximity to the town, the ability to walk into town, and the ability to take off and explore different areas of the island with a car. We had always hoped to be able to have a home in Nantucket, and the circumstances were right for us in 2017. The plan was that we would continue to rent the home, which we had, to rent the home, which we had bought from the original owner since it was constructed, and we would use the guest house. And I just want to take a second. The guest house is a detached, you're welcome to drive by, everybody does. It's a separate one-car garage on the first floor There is a full bedroom, full bathroom. We even have an outdoor shower in the back. Upstairs, front to back, living room, dining area, kitchen, and washing laundry area. So it works nicely for two of us, or if we have a friend come with us, that works well too. So I want to make sure that folks understand we have some options, which I'll explain a little bit more in terms of where we stay. Our plan was, again, that we would use both the house and guest house for several weeks throughout the year. Once we were retired, we would spend more time on island. Peter retired a few months ago, and that is how it is playing out already. He comes over a few days prior to my joining him. When we purchased our home, we were required to assume several leases for 2017. You will make note, as has been said, that is the year of highest rental utilization. We didn't have much choice. Our family could not come there as a family and have access to the main house till Labor Day week. We had no minimal say in any of that. So although that's the reality, it was 111 days, I believe is what was said in 2017. That was kind of like we inherited that, is the best analogy that I can explain. Our summer vacations in Nantucket were much anticipated by all of our family. As kids got older, they brought friends. We enjoyed crabbing, fishing at Great Point, the beach at Mattakasham, cookouts at Nantucket, etc. The island has been a special place for our two living children. Both were engaged on Nantucket. Our daughter met her now husband on Nantucket, and they were married, believe it or not, exactly 1 year ago today on Nantucket. The weather was horrible, but we had a great time. It was great. It has become a special place for our two grandchildren who enjoy using the zip line at the playground on Old South Road. The candy room in the rear of Force 5 is definitely on their top of their to-do list. The beach, surfing, going to the Athenaeum, the Whaling Museum, where our grandson gives tours to his friends like he is the mayor of the Whaling Museum, and rides on the beach. They eagerly anticipate their return in July. We enjoy entertaining family and friends at our home. It is I call it my escape from reality, and we come whenever we are able and the winds cooperate. That doesn't always work so well in the winter. We come year-round. If it's just the two of us in the winter, we will stay in the guest house so as to unnecessarily heat up a larger home, and it works really well. We have a Jeep on island. Sometimes we will decide a few hours in advance that we will come over, and we have the ferry schedules committed to memory and a lot of commuter books. We want to be good neighbors, and we have given my cell phone number to Ms. Ward and to 3 other neighbors. None have ever called with an issue. They might call looking for a vendor recommendation or to invite us to a gathering. Ms. Ward has texted us on 3 occasions, a leaking underground water line, bamboo from our hedge, and a patio umbrella that had been lifted by wind, which occurred when our home was not rented, all of which were responded to immediately, and with which on 3 occasions, Ms. Ward sent a text which said, "Thank you." We look forward to, in closing, we look forward to the zoning board's decision on what is considered acceptable use, and hope that the time-honored tradition of short-term rentals continues so that others, including my children and grandchildren, may thoroughly enjoy all that this beautiful island has to offer. I thank you for your service to the community. Thank you.
Thank you. Oh, yeah. Does anyone on the board at this time have any questions for Mrs. Grape? No. Okay. Did you have anything additional to present?
Oh, yeah, sorry, thank you, Mr. Hoffman. As I had whispered to Mr. Hoffman, and realtors in the room can attest to this, realtors with which we've worked, they put out their calendar without any guidance or input for us for the following year. And when I look at it and I see that it's out there, when our family makes decisions like, oh, we plan on going those 2 weeks in July, or we plan on coming for Christmas stroll, which we do, Thanksgiving stroll, daffodils, et cetera. We block it and say the house isn't available, but we have no input in the calendars being put out there. They're just listed, and then if we were to get a call, we'd say, gee, we actually plan to use it that week, and don't use it. I mean, we don't rent it, so.
Okay.
Thank you. Other questions?
Okay, seeing none. Do either attorneys have anything else to add at this point?
No, I think you've heard enough from the lawyers.
Okay. Did you want to call, I see Penny right here. Yeah, so would you want Penny to speak for you, or is she speaking as part of your presentation? Okay, sure.
We certainly, if you're having public comment today, we certainly have folks here for public comment as well.
Right, that's what I was trying to get at. So just
Yeah.
clarifying whether Ms. Day's presenting as part of your presentation or as part of public comment.
We submitted her letter as part of our presentation.
Okay.
We submitted the homework. Well, there's a letter that's in our packet. What's in the packet? I'd like to have her read. If I understand it, it's up to
It's fine, I just wanted to, just for procedural reasons, whether she's speaking as a member of the community or for the real estate community or as a part of your presentation.
I don't represent who's speaking for herself.
Okay, so then we're moving on, so then that's part of public comment.
Okay.
Okay, so let's get to that. Does anyone on the board, before we move to public comment, does anyone on the board have anything to ask? Okay. So then we'll open up for public comment. Since Penny Dye's already at the microphone, we'll let her start it off, and then I'll go to you, Billy. We'll see what's going on online, and then we'll go to members in the audience.
Thank you, Madam Chair.
Sure.
My name is Penny Dye, and I want to address quickly the notion of calendars on websites of real estate offices. We do have a 12-month calendar up for every property that we represent. There are only rates for the weeks that are available to rent. And if you look in January, February, March, April, and November and December, you will see that there are no rates, even if a week is showing there. It does not mean it's available to rent. Okay, I'm principal broker and owner of Atlantic East Real Estate. I just finished 2 terms as the president of NAREB. I'm also the chair of the Nantucket Housing Authority, and I hold a seat on the Nantucket Affordable Housing Trust. I've worked full-time year-round in real estate for over 40 years and have seen how vacation rentals have changed over the years. They are the major driver of our local economy. Nantucket is a vacation destination, and most people cannot afford to buy here, so they rent. The short-term rental tax, 11.7%, has been in place since 2019 and has generated over $80 million for this community since its inception. My family was fortunate enough to start vacationing here in the early 1960s, and in those days, rentals were either for the full summer or half the summer. Nobody was doing 1 or 2 week rentals. At that time, women were largely not in the workforce. That started to change, mostly in the 70s and the 80s. You had 2 people earning an income, less flexibility. People were starting to come for shorter vacations. As has been said, in the 1980s, we voted down any more development of large-scale resorts and hotels. Vacation rentals of people's homes have filled that gap. Over 90% of our overnight visitors stay in vacation rentals. For well over a century, Nantucket has allowed the rental of one's private home. This is a property right until it's taken away. The vast majority of people who rent their homes here bought on island, as did the Grapes, because they love Nantucket, and renting is a way to help defray the cost of ownership. The average number of days that owners rent through NAREB offices is less than 52 days per year. The rest of the time, they are using their homes or the homes are vacant. And as has been said, this is their choice. Over 93% of NAREB leases are for less than 32 days. People simply cannot afford to come here for longer. There is no question that the short-term rental of one's home is a customary use on Nantucket. Thank you. Questions?
Okay. Does anyone have any questions Joe, it looks
Yeah,
like
I
you
have one
do.
question. The 52 days, what percentage is that of the rental season?
52 days is less
You
than
said
two,
it's
two
the
months.
average. I know, but how long is the rental season?
Oh, the rental season, it depends how you characterize it. The height of the season is July 1st through Labor Day, which depending on the calendar year is 8 to 9 weeks. Okay. Then we have the shoulder seasons, mid-June.
Well, these 52 days, where are they bracketed?
In what months do those rentals occur?
Yeah.
Oh, July and August.
Okay,
Yeah,
thanks.
sorry.
I didn't say it.
Yeah. Anybody else?
Okay.
Thank you.
Seeing none, okay. All right, Billy, so do you have anyone online with a hand up?
Yeah, first up, we have Cathy Baird.
Okay, so, and how many, can you tell me how many people you have online?
Cathy is on. Bob Vadoni keeps putting his hand up and down, so I think he's looking to speak and
Okay.
probably just waiting.
So just two?
Just two.
Okay, so why don't we do those two first, and then we'll go to the audience? Okay.
Kathy, please unmute.
I'm muted. Can you hear me?
Yes, just one, I just want to say one thing, and you're the second person to speak, so this may not apply to you, but if we are, I think we will have a lot of speakers, so try to keep your comments succinct and let's not try to not repeat. If someone has covered your thing, you can say, I support what the person before me said or whatever, but try not to repeat what's been said.
Madam Chairman,
Yes?
perhaps we don't need the background of, I started coming to Nantucket in 1940, and I love, not the personal touch.
Yeah, so like
Yeah.
I said, keep it succinct and we'll see how we go. And if we're getting off track, we'll bring it back.
Okay, Cathy Baird. I'm a former member of the short-term rental work group. Just have 3 quick points to make to add on to what's been said. One is the vast majority of homes on Nantucket are vacation homes. And by definition, they are vacant most of the year. So that means to me that a vacant home is clearly a traditional and customary use of a Nantucket home. And vacancy is therefore part of the primary use. Of those vacation homes, only about 15% are rented as STRs. Second point is the federal census also categorizes homes. This does this across the nation as owner-occupied or vacant. And those statistics match what was found by the independent data aggregator assigned to this short-term rental work group. So vacancy is also considered a legal or valid primary use. And then the third point is that use is fluid over time for every family and it's unpredictable. I think the Grapes and Linda Grape did a good job of explaining how that happens for everybody. And just because a home is listed as available for rental does not mean the owner will agree to lease during that time. And it also means that the home is available for a long-term rental if the owner decides to do so. The bottom line is really it's the sole discretion of the owner. And a calendar is in no way a commitment. Only a rental lease is a commitment. Thank you.
Okay, thank you for your comments. We'll hear from the second person online and then we'll move to the audience.
Next, we have Dan Bailey with his hand raised. Dan, you're able to speak.
Thank you. Can everyone hear me?
Yes.
Okay. Thank you, Madam Chair, members of the board. I'm just going to speak very briefly. You will hear much more from me in 2 weeks. I'm an attorney at Pierce Atwood in Boston, as the board members know. And I do quite a bit of work on Nantucket. We represent Delaney Keith Trust at 15 Delaney Road. They are the defendants in the Quick versus Keith case, which has also been pending before Judge Vey in the land court. Judge Vey has remanded, there's been no decision in that case, but Judge Vey has remanded that case back to this board, and the board has a hearing coming up in a couple of weeks. I don't want to get into any of those specific facts because that's not before the board today. I just want to take this opportunity to express our support for Attorney McLaughlin and his client and exactly the arguments that they're making. And I think the comments just made by Ms. Baird are particularly compelling. Nantucket, like much of the Cape and the island, is a resort community. People have been renting houses, for, I'm 64, for as long as I can remember. And, it's just the very nature of those communities that single-family houses are rented on a short-term basis as an accessory use. Thank you very much, and I'll see you in a couple of weeks.
Thank you, Attorney Bailey. Did the other person that had their hand up and down, is it?
Yes, we have Bob Vadoni is up
Okay.
next, and Bob, you are able to speak.
Thank you. Forgive the hand going up and down. I'm used to seeing the hand up and it wasn't showing on my screen, so I wasn't sure it was getting through. I have a question through the chair for Nina Pickering, and this goes to regarding what's considered days to be used, whether they're vacant or available. If I don't make my house available for January, February, and March, and I take it off all calendars, because I assume I might want to come up, I may or I may not. But since it's no longer available to rent and it's not listed anywhere as available, do I get those 90 days added back to my actual usage? That's the question.
Madam Chair. Thank you for the question, Bob. That's a good one. I think that is within the discretion of this board. If the property is not available to rent during those times, as to whether that would be counted towards residential use or rental use. What the judge has looked at in this case is the actual use of the property, in the days the property is used. So, and again, I am absolutely not asking you to delve into anyone's tax returns, but the representations that parties make to the government as to their use of the property, I think is relevant, and certainly the judge found it determinative in this case. I would also say this. The problem with simply Xing out the calendar and counting those days as residential use days is you are handing a gift to the investor short-term rentals to be completely legal as an accessory use. And that is something that certainly the town meeting of Nantucket, as I understand it, has voted against for 4 years now. The reason that's the case is because you could have someone or a conglomerate that owns 14 or 15 different houses, rent them for 3 months a year, close them down and leave them vacant for the remainder of the year, and then chalk that up as a legal accessory use. And that is still doing the same damage that the courts and many folks who live next door to short-term rentals have explained to this board and to the court as far as the impact on the fabric of the neighborhood. So if you're going to count the vacant days as in the numerator as residential use days, you are effectively legalizing full-time short-term rentals. I want to make it very clear that that's what this decision would mean.
That's everyone online for now. We'll circle back to online.
Yeah, Mr. Vadoni's hand is still raised. Are we?
Did you have a follow-up, Mr. Vadoni?
Yes, I do. I greatly appreciate everyone's concern of not wanting strictly full-time corporate rentals. I am not a corporate owner. I'm an individual. And to penalize me because I make my house unavailable for renting and throw me into the same class as a corporate rental, I don't believe is fair. So that's my reason.
Okay, Thank you for your comment.
No more hands are raised.
Okay. So we're going to hear from a few people in the audience, and then I think we'll take a quick break at 2:30, and then we'll come back at 2:40 and start back up. Is that, okay. So I don't know which one of you was up first.
I think you were up first.
Okay. So if you can just state your name for the minutes, and you have the floor.
Thank you. My name is Caroline Boltzer, and I am part of a family who's been here for 7 generations. Sorry, but seasonally. I'm now moved here myself, and I'm a voter. And I wanted to address the attorney Pickering-Cook's characterization of our history of short-term rentals. My grandparents rented our house that I rent now I know in the 60s, possibly in the 50s, but I do know in the 60s. My mother and father rented it. I rent it. I hope my son will and his cousin will be able to rent it. And if they can't, we will not be able to keep our 102-year-old house that my great-grandmother designed on the back of a paper bag. So that's my interest. But I'm also, I have a PhD in social science. I'm very interested in history, especially Nantucket. And I have been digging around to understand what is the history on Nantucket? How deep does it go? And it's very intriguing because to contradict attorney Pickering-Cook, the traditional use was not to defray expenses. Here, people refer to themselves as proprietors. I have several pamphlets here advertising them, one from 1929. And there are rentals listed in here with the proprietor. The word is proprietor with the person's name. They're often women. And they have several because it's a business. They are trying to make money. They are not defraying expenses. So I assume from several of these types of things that I've collected that they were doing it because Nantucket was a seasonal resort community, and that was, they were offering a service. And at that time, houses were abandoned and there wasn't much going on here. So it was good for the houses, our architecture, the preservation, to have them taken care of and rented out. And that was part of what we were. It's part of what we are now. I have, and here we go, Sports Illustrated, 1958. I'm sure some people have seen this one, but I love this little quote here. The activities of people who own summer houses or rent them regularly center around the Yacht Club and the Cliffside Beach Club in Nantucket Town, and at the Sankaty Head Beach Club and the Sankaty Head Golf Club at Sconset. So it's referred to as, you either own or you might rent them out. It's both. So I just wanted to put that out there. I hope that's helpful. Yes, some people rent their homes to defray expenses, I'm sure. But the idea that people are conducting them as business has been around really, I would say, from the turn of the century, if not before. So I do think that needs to be accounted for. And if we don't like that now and we want to pass laws to get rid of that, like Article 60, that's fine. But I think we should be accurate about the history. I also want to point out that Nantucket is one of the developers, I think, of STRs. And I think we've been doing it for well over 100 years. Here I have something from 1935 where it's the Nantucket Yacht Club, it's the Hospital Fete, and in it, Gladys Wood is advertising. I see Curtis Barnes over there. I know that he and his wife were involved in developing very well-run, well-orchestrated family houses for rent that were taken care of by a real estate agent or somebody like a Gladys Wood. I think she was probably the earliest prototype of Airbnb, and she's 1935 advertising here in the Yacht Club's Hospital Fet pamphlet. So my point is that Nantucket has it worked out, and I know that there's been a lot of complaints. I know there are complaints. I know there are problem properties, and I know that we need to take care of them. And after 4 years of all of this, I think it would be unusual to find somebody who isn't really on top of vetting who's coming into their house, whether through the real estate agent or, that's one of the reasons I'll finish by saying, I sometimes use Airbnb because I get to talk to the people who are going to rent my house, and I get to ask them all kinds of questions, and I do. And I am totally on top of that. So I don't think that Airbnb is the culprit. That's just my opinion. And I also, my last point is to address Nina Pickering-Cook. Nantucket has not had an explosion of short-term rentals in the last 10 years. Nantucket's population doubled between 2010 and 2020. So everything has exploded. Restaurants, cars, houses, building, all kinds of things. And even our hospital has more than doubled in size. And this is, therefore, I think that accounts for why we have more short-term rentals. I understood we had 1550 right now, 17 I'm hearing from Penny. And we don't have data from 10 years ago, but I know we have data from, I think it's 2019, and it was, it's a couple hundred less. So we have the pandemic glut, and now it's starting to go back down again. Thank you so much for letting me speak.
Okay. Thank you for your comments. We'll hear from.
Maybe I should have gone first. I really enjoy hearing the history, and to tell our story, we actually have to give a little bit of that you don't want to hear. So I'm sorry to make a little bit of repeat. Good afternoon.
Oh, yeah, I'm sorry. Could you just state your name?
My name is Abby Camp. I've rented my home for additional income for about 40 years. It helps defray dramatic rise in taxes, insurance, and living on the island. I live in my great-great-grandmother's house and moved to a small cottage in Sconset for the summer. My ancestors from the Coffin family packed all their belongings every summer and sailed with their 8 children to Tuckernuck. This was after the rich whaling days, when Nantucketers went back to living off the land to make ends meet. It must have been the birth of the Nantucket Shuffle. Fast forward to pre-COVID. I'm not sure exactly when it started, but signs were evident that Nantucket's character was changing. Sales doubled, housing became scarce, my rentals practically cut in half. At the HDC, we had a backlog of over 250 applications, most wanting main dwellings, guest cottages, swimming pools. We had become an investor's paradise. In 1970, our leaders in the community had the foresight to see that our beautiful island could fall prey to unbridled development. They designed the zoning maps for the entire island to preserve our neighborhoods. The zoning board, the select board, the planning, the HDC all have the ability to uphold our island's character and integrity, not cater to offshore investors. Please uphold the zoning we have in place. Protect our people, such as myself, who is here for the long haul. I'm not leaving. I've served on the HDC for 15 years. I volunteer on the Council for the Aging. Investors can easily pick up their investments and move on to the next hot spot. Protect Nantucketers who for years have rented in the traditional way, living in their home and renting to keep living on the island. Thank you.
Thank you. I'll go over to this side.
My name is Lisa Wynn, and I have been a broker on the island for. My name is Lisa Wynn, and I've been a broker on the island for 40 years. I submitted a letter to the board, which you have in your packet, so I'm sort of summarizing some of that. Over the past 4 decades, I've dealt with hundreds of homeowners and negotiated thousands of short-term rentals, witnessing the Nantucket tradition of owners renting out their homes. Short-term rentals have been a tradition on Nantucket for longer than I have been here and longer than anyone can remember. The homeowners that I work with own a house on Nantucket because they love the island. I really honestly don't know who all these investors are that people are talking about, because all the homeowners that I work with love their homes and use them themselves. They spend as much time here as possible in the rentals as a way to defray, and use the rentals as a way to defray a portion of the cost of home ownership. Not many of our homeowners rent for more than a total of 6 to 8 weeks. Short-term rentals are a necessity for the island economy, especially in the off-season. Without private homes renting for long weekends, we would not have enough rooms for island visitors to handle the numbers of people who come here for weddings and who also come to enjoy all of the wonderful festivals that our Chamber of Commerce has worked for years to promote to support our economy in the off-season. And also the short-term rental tax represents roughly 10% of the town's budget, which amounts to millions of dollars per year. Short-term rentals do not take away from the year-round rental housing stock. There are very few houses that once were occupied year-round that have sold and then become short-term rentals. There are some, but not the hundreds that people are trying to make you believe. In response to Ms. Cook, I really do not believe that the rentals have exploded over the years. If anything, we have less rentals in the last couple of years since COVID as we did before. And also going back to the whole calendar thing, we have hundreds of rentals available to us. We don't rent them all the time, but those calendars are, as Penny said, they're open, and those weeks are open mostly because we don't have the time to block all of them off. We just put the prices in for the summer, and if we think that a homeowner might be interested in a rental, we call them, and either it's available or it's not, as the Grapes have said. So to say that all these houses are open 12 months a year is just not the case. And if anyone has any questions.
Okay. Thank you, Ms. Nguyen. We'll go over here to you, sir.
Thank you very much. My name is Eric Sultan. I live at 3 Meadowview Drive here in Nantucket, and I've been very lucky. I've been able to retire here, and I've been living here full-time since 2014. I first started coming here in 1980 and built my own home, and have been here living since 1989. So I just have a question for you all. It's a very simple question, which is, folks who choose, I do not, but other folks do choose to have renters come into their home. I pay residential tax rates. Do those folks also pay residential tax rates for the entire time in which they have that home? Or are commercial rates applied to the quote short-term rental time, and then residential rates applied to the other times, whether they are here or not? That's all I want to say. Bottom line is, if commercial rates are not applied to the short-term rental time, that is money that the town loses. Worse, residential rates in combination with the lack of commercial rates means my tax rate as residential only goes up. I don't think that's fair. I don't think I should be penalized or supporting those who wish to short-term rent. And I would leave the question now to you all. Thank you.
Okay, thank you.
Hi, Kit Murphy. I have 2 questions. So if you want to take a break because it's after 2:30, that's perfect, as long as I can be the
Yeah, we'll
first
start
person
back
up.
up with you.
Pardon me?
We'll start back up with you when we come
Yeah,
back in 10 minutes.
perfect.
Okay,
Great, thank you.
great. Thank you. Oh my God, I'm frozen. I'm so.
I'm never cold.
I'm
I am
so
never
cold.
Now I know what it's like to be
Jeez.
over the hill, as they say.
You're not.
Keep crossing that mountain.
Billy, can you ask, is there anything you can do about the temperature?
Yeah, I can turn it up.
Yeah, just turn everything off. All right, everybody. I think if everyone's back in the room and we can take our seats, we can start up again. Elisa and Jim. Elisa. Just so we can, we're not here. Okay. Okay, we're gonna start back up. And Ms. Murphy, you have your questions. You have the floor. All right, hold on one second. We're just gonna start back up, guys. And so Kit's gonna go first. All right, we're good.
Two questions and then maybe a really brief statement.
Okay.
First off, I don't and have never short-term rented my house. Penny will know me as being a July person when I first came to Sconset, and now I'm here year-round. My question through the board is to Nina Pickering-Cook. When you said the short-term rentals exploded over the past 8 to 10 years, am I correct that you were talking about the for-profit corporate rentals?
Madam Chair, may I answer? Yes. So again, I can certainly provide, if that phrasing is causing people heartburn, I can certainly provide you the data on which I'm basing that. But we've all seen it all over the country, right? In every vacation and high-end resort locale across the country, they've been seen as a target for investors. Nantucket has seen that as well. That type of STR use as primarily an investment property is what I was referring to as exploding in the last 10 years. But again, I can provide that data, which I don't have off the top of my head.
I would appreciate seeing that data.
Okay, great.
Yeah.
One comment.
And Elisa just had a comment, and then Kit will go right back to you.
I have not seen, you said the whole country it's exploding. I haven't seen that. Where
I'm
are you
saying
referring to?
vacation and resort communities across the country. I'm not saying
What are
the
you
whole
saying
country.
about them? They've exploded? I don't know what you're saying.
I'm saying that the target of those areas for investors in the short-term rental market, taking single-family homes and turning them into short-term rentals in those high-end resort and vacation communities has been an increasing investment opportunity in the last 10 years. That is essentially a new use that homes are being put to in those areas.
And where have you seen that?
There's plenty of documentation I can provide you, and it's certainly been well covered by the media as well. I'm surprised if you haven't seen it.
I have not seen that.
It's interesting.
Okay, Kit, your second.
I think, not meaning to put words in Nina's mouth, but I think she's talking about places like Aspen and ski resorts and other beach resorts. Somebody, and I forget who, said that the ZBA is not a policy-making board. And that was kind of news to me, and I'm just wondering if you do or do not agree with that.
So in the past, I know Nina had a different opinion than we did, right, at some point about that. But in the past, where we've been asked to make decisions about the short-term rentals and whether it was a commercial use, which is different than what we're looking at right now, and being asked to uphold the building commissioner's determination, we have said that it was not our job was to follow the regulations as they're written and to not make new policy for the town. That's more the job of the planning board, select board, and town meeting.
Madam Chair, if I could clarify, I absolutely agree with you. You are an adjudicatory board.
Right, exactly. That's what you had said before.
So
yeah.
you are not a policy-making board, but in adjudicating, you certainly interpret your own zoning bylaw.
Right, but we're not, right, we're interpreting the existing zoning bylaw. We're not creating new bylaw. So
Okay,
that's what it meant by that.
I wasn't just limiting it to the current short-term rental issue.
Yeah,
I
so-
was just asking for my own edification.
Yeah, so that's where that came from.
Okay, great,
Yeah,
thank you.
Okay. Mr. Barnes?
Curtis Barnes, I just wanted to offer you a technical point that I find regularly. If you are registered with the state as a rental, which we have to do, the state expects you to report on a monthly basis the amount of income that you've received. Every month I get a ding from Mass Tax Connect that says, what was your rental in January? And I put in 0. What was your rental in February? I put in 0. So the state, through Mass Tax Connect, is monitoring registered rental properties on Nantucket, and I'm sure every place else. I just want to make sure you know that that process is built into the registration, and it may be helpful in looking at days, weeks, or months that are rented. Thank you.
Thank you. Okay.
Hi, Patsy Ray, for the record.
Patsy Ray. Okay.
Can you hear me?
Yep, I can. Thank
Okay.
you.
All right. In June 2021, the highest court in Massachusetts held that short-term rental use of one-family home is inconsistent with zoning purpose of the single resident zoning district. Towns across Massachusetts understood the precedent of this case, Schuyler versus Linfield. I'd like to read 3 excerpts from Schuyler versus Zoning Board of Appeals in Linfield. The plaintiff's argument is fundamentally flawed because it fails to recognize that short-term rental use of a one-family home is inconsistent with the zoning purpose of the single resident zoning district in which it is situated, i.e. to preserve the residential character of the neighborhood. Use of the zoning regulation to foster stability and permanence is compatible with long-term property rentals because the long-term inhabitants have the opportunity to develop a sense of community and a shared commitment to the common good of that community. And lastly, where short-term rentals are at issue, however, there is an absence of stability and permanence of the individuals residing in those districts, and the goal is necessarily subverted. Thank you.
I didn't have my mic on. We'll have Melissa Philbert go first because it's her first time speaking, and then we'll go back to you to follow up for your second.
Hi, I'm Melissa Philbert. I live at 4 Silver Street, so in the neighborhood that is before you today. And I'm just speaking for myself, not for anybody else. I just, in terms of this customary, the issue of customary, and I agree there's those 3 words you have to look at in the zoning code to define what an accessory use is. I had just wanted to recount a conversation I had with Andrew Vorse back in 2008 when I was asking about a master plan and long-term planning for the town. And he looked at me and he said, you know, you can't long-term plan. You can't do it anymore. Change is too frequent. We don't do planning anymore. Because think about what happened, you know, who could have anticipated fast ferries? You know, we couldn't have guessed the change that those would have. I mean, who's going to guess what will happen when we lose fast ferries in the winter? Because can't do that anymore, what that will do to the kids and the sports teams. And at the time, I have to say, I was really irritated at him. That just wasn't the answer I wanted, and I really disagreed that we shouldn't be doing more planning. And I think, you know, honestly, I think I agree with him now. I mean, change happens so rapidly, and things change in really disruptive ways. And so when I think about the word customarily, and I think about what's happened since online platforms like Airbnb went global in 2011, that is so different from the Nantucket rental market that I understood when we first moved and bought our house, that I invested in this community based on. I know that the pattern of rentals before you, but I also know that the house the grapes were in was a year-round house when it was first occupied there. A local contractor lived there year-round. It got sold and it moved on, and so be it. But there is a linkage in my mind, and I'm not a broker, I don't have all the other statistics, but there is a linkage between the loss of year-round homes and conversion to short-term rentals. Who would have thought on that busy street that that would be an attractive vacation home for someone? I mean, a contractor lived there, and that was an important home for him. We have another short-term rental 2 houses down. They rent all winter to a contractor. There's 5 guys who live in that house. They drive in 1 big truck. They shower when they get home. They leave every light on all night. They're there all winter. I can't complain about them because they're here working, they're providing a service, they're contributing to the local economy. That house and property is used. It is rental, but it is, and then she's here for a little bit and then is heavily short-term rented all summer. She's here for a little bit and then the contractors come back. And that's been a pattern of use where if I had to look at, as we've been discussing it, that winter use is a rental use. And that's, you know, fits into this whole occasion. It's not just left empty and vacant. I do think things have changed with the advent of online platforms, and I understand the groups work with local brokers, but there's a lack of intermediation. There's a lack of somebody who's really there, who understands the property and cares about it, and there's a lack of policing, and it's changed. The character of it has changed. The character of my neighborhood has changed. And I do think that you need to look at subordinate, and I think you need to look at it in terms of the number of days that the hot property is occupied and actually in use, and that this vacancy argument is spurious, and I won't take any more of your time, but thank you.
Okay, and back to you, and then do you have people online?
Yeah, we have
Okay,
hands raised online.
So let's hear the 2 people at the microphones now, and then we'll go back to online, so.
Thank you. I'm sorry to speak a second time, but I just wanted to add in some statistics since, again, Attorney Pickering-Cook was talking about the explosion of short-term rentals on Nantucket. And we're talking about residential, the erosion of residential neighborhoods. Nantucket numbers are, we're confused about the exact numbers, but they say we have 20,000 here in year-round, and then it explodes to about 80,000 in the summer season. And from the zoning perspective, that's such a massive change that zoning has to figure out how to accommodate the difference because it's materially a different thing. And so the summer, people coming in for the summer, there's families and guests, renters, everyone's coming and going all the time in all of the neighborhoods, but especially quite a few of the neighborhoods on the island like Brant Point or Sconset, or there's some places that are known as summer residential. Brant Point, I think, has like 4 voters. I'm one of them. And so there's a churn that happens regardless of whether it's renters or not, because we have guests coming and going, everybody does. So the idea that the neighborhood fabric is eroding, that it just does not fit in certain places. I know that that is true in some places, and I don't want to deny somebody's experience of their own street or neighborhood, but I'm just asking you to consider that Nantucket is unusual in this way. The other thing is the town of Nantucket hired a statistician for the short-term rental working group, and that statistician from Process First published about a year ago, corporate owned on Nantucket was 2.2%. So I just want to make sure that we are all talking about the same number. It is 2.2%, and of course now that's going to go down lower. That's extremely important as a statistic. You can't, there's no fudging that. Thank you.
Okay, thank you. Hi.
Leslie Forbes. I'm not sure, is this on? Yes,
It
now
is.
it is. Thank you. I wanted to speak to the economic impact that we have heard from 2 realtors, and I want to give a counterpoint to it. We are all very clear on the income the town receives from the short-term rental tax. We do not make the linkage with the expenses that come from short-term rentals. I can't even add up the amount of money that we have voted through for affordable and attainable housing. That's an expense not entirely related to short-term rentals, certainly, but short-term rentals demand more service. People want those jobs. They have those jobs. They don't have a place to live. It has overflowed. We need more nurses because the emergency room is bigger. In any case, we need more policemen. We need more firemen. So there's an expense side to this that we seem to just not link to the increased intensity of use that is happening on Nantucket. That's my point.
Thank you. We're going to go to, but I'm just going to ask you to hold for 1 minute. We're just going to go to online or Zoom.
Yeah, we have Mike Herlihy.
Okay.
Mike.
Can you hear me?
Yes, thank you.
All right, I'm sorry. It's Mike Herlihy, 6 Salty Way, a family, dream home, et cetera, common story. When we've been short-term renting since 2000. Just responding to the gentleman who was concerned about the equity and justice and level of taxation of these properties and impact on his property tax. If one, in our case, and I can only give you one case, we pay in taxes, if you add the property tax to the short-term rental tax, and some of that goes to the state, it's more than double the property tax. So I don't want to leave the board with the impression that the short-term rental owner does not contribute to additionally to the needs of the town. That's all I had to say.
Okay, thank you for your comments. Do you have anyone else online?
No.
Okay, so I'll go over here and then I'll go over here.
Okay, Charity Benz. Just in case you don't know it, which you probably do, Schedule E of the IRS form for supplemental income and loss for real estate specifically identifies as a separate issue vacation and short-term rental. And you are obliged to identify the property, put in the type of property, which would be short-term rental, and then there's a column here for fair rental days, and there's one here for personal use days. And so for people who are renting and filing their income taxes the way they should be filed, counting up the days that you use your house personally and the days that you rent them should not be a big problem. You should be able to do that. And it's, you know, it's 1, 2, 3, 4, 5. 1, 2, 3, 4, 5. It's a very straightforward thing, and people who aren't doing this properly are running the risk of an audit. Thank you.
Okay, thank you for your comment.
Thank you, Penny Dye. I just want to clarify something, add on to something that was said by a previous speaker about the expenses. There are 12,600 dwelling units on Nantucket. Of those, the last year for which there are statistics available, 1,758 collected and filed the short-term rental tax. The houses on Nantucket in the summer are going to be occupied by someone, whether it is the owner's friends and family, or a tenant, long-term or short-term. Services and the need for increased services is not changing because of strictly short-term rentals. It's because of the popularity of Nantucket. Thank you.
Thank you for your comment. Attorney Cohen?
Thank you, Madam Chair. I'd like to clarify that although I am counsel to the Keiths, who are the other zoning matter before you, not today, that I'm speaking as a independent citizen. We've heard a lot today, and I'd like to focus on some of the legal points in front of you because that's what I do for a living. And I think it's pretty clear, I think everybody would agree that Nantucket has a history of summer vacation rentals that basically goes back to the mid-1800s after the collapse of the whaling industry, the gold rush, and the Civil War. Like, it's undisputed that we've been doing that for 150 years. And I think it's also undisputed that that has changed basically since the 1960s as vacationing has changed and come from summering being all summer to summering being, you know, a shorter period as people's lives have changed. But I think it's undisputed that short-term rentals on Nantucket predate the zoning code and have been continuing since the zoning code was adopted in 1972. And I would point out to you that the town of Nantucket and its zoning enforcement officer and its building commissioner have brought exactly 0 enforcement cases for short-term rentals because it was understood to be a customary and allowed legal use. There are 4 lawsuits related to this, all of which are filed by neighbors, none of which have brought by the town ever. So if you're looking to see what the town's policy is on this, I think the building commissioner has said it to you 4 times and you have supported him 4 times. The zoning code has also encouraged Nantucket use of single-family homes and private homes as where vacationers stay over and over multiple times in all the votes that we've taken on this kind of an issue. And that's why we have only 1,000 hotel rooms and essentially no major spas and resorts and places. If you go to other places, what you're going to see is high-rise hotels and you know, really nice resorts. We don't have those here because we don't want them, and we have essentially ruled them out of our zoning code. But we still have 50, 60, 70,000 people who come on a weekly basis in the summer, and where do they stay? In private homes. And again, 0 enforcement or illegal zoning cases have been brought based on that, even though it's been happening for 50 plus years. Attorney Pickering-Cook is a very good attorney, but she seriously, I think, misconstrued something from the case that I think is important to point out. Judge Vey did not find that the grapes failed to meet the level for primary use based on their 45 days or 50 days or whatever it was that they used their home. What he found was that Nantucket's zoning bylaw does not provide for a category that includes short-term rentals, and therefore short-term rentals are not an illegal use, they are just not an allowed use. And that is what the case says, and I believe that that's what town council would agree with, and you're welcome to go look at it yourself. He didn't say that they failed to meet the criteria for primary use. He said that Nantucket's zoning code does not expressly provide for short-term rentals as a primary use. And that is the failure, the current failure of the Nantucket zoning code, and it's why it needs to be amended to allow short-term rentals, because it doesn't have short-term rentals as a category. What he said was that the transient nature of short-term rentals differentiates themselves from residential use such that they need their own category. He also said that people who keep bringing up this issue about commercial use are asking the wrong question because it's not a commercial use. It's a residential use. It's just different than private residential, than personal residential use because of its transient nature and therefore needs its own category. So that's what Judge Vey said in this, and that's why, but what he also said was that in terms of whether or not the standard for ancillary use has been met, he wasn't going to weigh in on it because he's not the court of this area of first resort on it. The building commissioner did not address that question. You did not address that question, and he was not going to go first, and therefore he remanded here. So that question has not been addressed at all by the building commissioner, by you, or by him. And so the suggestion that he has already made a decision on how those 45 or 50 days should count, I think was misleading at best. There is no rule in Nantucket zoning code that says you have to use your house in order to be able to rent it out. Find it in the zoning code. It's not in there. There also is no history that says you have to use your house in order to rent it out. I will give you several examples that I think you're all familiar with that will demonstrate that that's true, none of which involve investor-only whatevers that we're talking about here. We all know families who live here, whose kids live here, the parent dies, and then the family rents out that house because nobody needs to move into it, but they don't want to sell it, they want to keep it in the family. And in fact, the cost of living has gone up so much, that rental is the only thing that pays for college, pays for braces, that pays the mortgage, that pays for hockey, that pays for the high cost of living here, you know, that pays for a $25 hamburger if you can afford to go out for one. Nantucket families rent out family homes that they don't use in the winter because they inherit them. That is a common occurrence. Secondly, Nantucket families rent out homes because they want to retire to somewhere warmer or because they get sick and need to move off island for medical purposes. And those homes then become unoccupied in the winter, but are used to pay for retirement, used to pay for medical expenses, used to pay for nursing home expenses. And they are never occupied in the winter, but they're rented out in the summer. And you all know families that do that. So the suggestion that the unoccupied house is solely the venue of the investor from Connecticut or whatever is a gross mischaracterization of what local families have done for a couple of generations here in order to make ends meet. And if you say you have to live in the house for some time, first of all, there's no place in the zoning code that says that. But second of all, you're going against these local families that have a tradition of using those homes to make ends meet, or to pay for their medical expenses, or to pay for their retirements. And those are just a couple of examples. And frankly, on the flip side of it, this idea that the vacancy has to be counted, can't be counted, makes no sense on its face. So for example, just in practical terms, if you're saying that your summer days, your rental days are based on how many days you live there, well, half the year takes place after the summer season, so how would you know, right? So I'm gonna rent out the house in the summer because I'm gonna stay here in the fall. How do you deal with what if you get sick and you have to go, the hospital? Oh, now you can't do it, so you violated zoning. I mean, it makes no sense. In practical terms, it's unenforceable, but it's also nonsense because it's not based in history or the law. It's also not based in Nantucket zoning code, and it's not based in statutory provisions. Nantucket zoning code, as my brother said, says that a dwelling is a building that is either occupied or intended to be occupied for habitable purposes, and then it goes through what those habitable purposes are. It only requires intention to occupy. And there's case law, the Madelone case, which takes place on Western Avenue, but also the Cox case and the Ravinsky case and some other cases in which the courts have repeatedly said that using a house does not require occupation, it just requires other activity for the homeowner. And I would assert, and those cases actually say, as one of the examples of uses, that holding out a property for rental or sale while it's unoccupied, is a use of the owner, okay? And if you take the flip side makes no sense, because if the days that they didn't live there were somehow a problem, that would mean that nearly every summer house also isn't allowed, because if we're saying that you're not using your when it's vacant, that is somehow a problem, that means that the houses over on Hulbert Avenue or Lincoln Circle that are used for 2 weeks a year, well, those 2 weeks might be fine, but then the other 50 weeks that they're being unused, so that doesn't count. We're going to count it in one way, but we're not going to count it another way. We're going to say, oh, it's okay to count them for summer people, but you can't count them for other people, right? I mean, it makes no sense to suddenly say that vacancy is a legal use for certain people, but vacancy is not a legal use for other people. I don't think that the board has the ability or frankly, the desire to do that, nor is it in the bylaw, the statute, or our history. I think that requiring occupation is taking a policy that people want and asking you to read it into the bylaw where it doesn't exist. And it's asking you to read it into the case law where it's against the case law, and it's asking you to read it into the history where it doesn't exist. The idea that you should do this because if you don't, then you're going to be allowing investor-only STRs, whatever that means, is, I think, a really insulting and inappropriate statement for people to be making. First of all, it's not actually the question before you. And second of all, it is clearly a policy decision that is not, that you've already stated is not what you're doing here. You're not supposed to be making decisions based on whether you like or don't like the activity of some owners. Like, and you're being asked to throw the baby out with the bathwater by saying, oh, well, if you allow for this legal use of summer vacation homes to also do a little STRs, you shouldn't do that because some other people who we want to vilify might take advantage of it. You know how we deal with that? Town meeting writes rules that says this is allowed and this other stuff isn't allowed. Town meeting, as you know, is the legislative body of Nantucket, and that's where those decisions should be made. As this board has in its past declined to make policy decisions, I would encourage you to do that now. I would encourage you to stick with the history of Nantucket of allowing for some short-term rentals and not getting into any decision about what off-season use is required. There's so many days here, this date counts, this day doesn't count. All of those are policy decisions the town meeting should be making. This is clearly an allowed use, it's an accessory use, and it is a legal use. And all the arguments that we heard about the impacts of STRs on neighborhoods, again, I agree with that those should all be mitigated, and town meetings should be taking action to do that. You shouldn't be asked to create rules that deal with things that aren't actually the question in front of you. So I'd ask the board to just stick with the questions in front of you and determine that that any use for less than half the year is an accessory use. The use does not require occupation, and that this is consistent with Nantucket's tradition and history. Thank you.
Hi, Patsy Wright again for the record. You know, I was just sitting here and listening to a lot of people talk about inheriting houses. And what are they supposed to do? You know, how can they keep them, you know, because they inherited them and they have to rent them. I'm a sailor. I'm a really passionate sailor. And if I inherit a 45-foot Hinckley and I can't afford the $50,000 a year it's going to take to maintain that boat, and it's virtually uncharterable because the person that could charter it would have to have skills that are unlikely I'm going to find to charter that. So I got to sell it. I hate it. This is the boat of my dreams. My parents have had this boat for years. I inherited it. I can't maintain it. I cry. I have to sell it. And I think, you know, it's kind of elitist, really, for people to stand up and say, oh, I've inherited a house and I can't afford to keep it. Why can't they rent it for 30 days? Is there a problem with that? Do they have to rent it by the week? Do they have to rent it by the weekend? Why can't they just rent it for 30 days? 30 days. I mean, is that so bad? Rent it for July, use it in August, use it in June, use it in September. I've just been standing here and it just felt compelled to come and say those things.
Thank you for your
Thank you.
comment. Okay.
Madam Chair, just extremely briefly, my good friend Patsy, who I've spent Christmas with, I agree with her, except that rule doesn't exist anywhere. And she's asking the board to write it in.
Mr. Marklinger?
Well, it seems like we're getting kind of far afield.
I was just gonna say, I think we've
You know,
run our,
we're going way to boats and nice legal arguments, even though you're not representing anybody. But I'd like to get onto the case at hand, not.
so that was where I was going.
Okay, sorry.
With that last, right, so I think we've heard from everybody, a few people, a couple of times to follow up. Is there anyone else online that wanted to speak? And then after that, just, is there anyone else in the audience who wants to speak, or has everybody had an opportunity? Okay, looks like I don't have any hands raised here, so let's hear from online, and then we'll talk about what we want to do next.
We have one hand raised, and I think we could call comment after this hand, but Linda Dolphin, you have the floor, Linda.
Yes, thank you. I have been a short-term rental owner on Nantucket for 25 years, and I have had varying accounting opinions on how I'm supposed to account for the days that I stay in the house when I fill out my tax return. And the one that I've researched myself and makes the most sense is that I don't have to report any days on my federal tax return as actually use days in my short-term rental if I've been working on the property consistently. So as an example, I was just there for 2 weeks and spent almost every hour there working. We had painters there, we had carpets cleaned, we had lawn work done. And so those 2 weeks do not count as my staying in my house according to my income tax return. So I just wanted to rebut Mrs. Benz's comments that those numbers would be accurate on an income tax return. Thank you.
Okay, thank you for your comment. So we've run the course on our public comment for today, it looks like. I think we can talk amongst the board. We're at 3:21 right now. I don't, given time constraints for some people, and we are done with this room by 4 o'clock, I think a lot of information, unless the board has some questions for either council or specific questions for each other, I think it might be prudent to talk about continuing this till a date certain, give us all some time to absorb what we've heard and perhaps reread some of the things in the packet that we were given and come back to do some deliberation. Does that sound appropriate to, yeah?
It does.
Okay.
I do have a question for George.
Okay,
Pucci.
George,
Just, there's a lot of discussion about the findings by Judge Vey. And I'm wondering, because, I mean, I can try to read his decision, but I'm not a lawyer. Is there a way to for you to give us a synopsis? Because we've heard both sides of the equation on his findings and what he came to regarding the vacant days and other parts of the decision that I'd like your interpretation of.
Yeah, I'm happy to provide that. And I think particularly helpful would be you are allowed to bring in some additional facts, and they were specifically referenced, in customary practices and things like that. You aren't allowed, in my opinion, to, rehear all the evidence. In other words, the factual findings Judge Vey made, I do think are binding, and it would be helpful to pull those out for you and show, what the facts are that are established, and then, anything further that you find that is relevant to the accessory use, you can add to the record. But for sure, you are bound by the facts that Judge Vey set forth in there. That was based on voluminous materials that were submitted by the parties in the lawsuit.
okay, so George, you're going to pull together for us a sort of baseline of the facts that have already been determined. And then if we find, then we can add to those if we have additional items. But that would be good.
Yes.
That would be great to have just the baseline.
Sure.
Yeah.
In just a quick, okay.
Yeah. And did you want something, sort of my opinion on on the legal issue that he addressed, or
I think
something
so,
short?
because I think, Nina Pickering-Cook has brought up this debate and that he specifically ruled on vacant days. And maybe he did, maybe he didn't. I don't know. I haven't read the decision. I wouldn't be able to understand that completely. So yeah, I think anything that's been discussed from either side in terms of their interpretation of his ruling
Sure.
and what we're supposed to do with that is important because, I believe that we all understand that short-term rentals, like it or not, have been part of Nantucket for a long time. I do think that they have changed dramatically since the online platforms have started. I live in town. I've lost a neighborhood that used to be full of local people, Steve Butler's family, lots of people that are now, one is a short-term rental, which is, kind of besides the point, but it's sad to see these neighborhoods change. And I loved living in a neighborhood where I had year-round people living with me, and that doesn't happen anymore. So it's really trying to understand, the three words, accessory use, and what that means relative to primary use. And I think a synopsis of your legal opinion and of his decision would be helpful for lay people like myself.
Happy to provide that. I was going to make one suggestion, Madam Chair,
Sure.
too, is I would keep the hearing open for your, I wouldn't close the hearing and just schedule deliberations. I would keep it open because
Oh, yeah.
people may want to make some
Yeah, oh, yeah.
submissions. You might want,
Yeah.
somebody might find out, oh, I didn't even know that was going on, and I
Yeah, I
wanna-"
wasn't intending to close the
Yeah.
hearing. I was just intending to, instead of start getting into the meat of it and then having to try to figure out how to, the date certain and whatever. We're almost at 3:30. We had to be out of here in 34 minutes anyway. So I think if we can continue till a date certain, and the suggestion would be, if allowable, I would suggest, and we would need a motion for this, to continue to the date certain, that we have the first hearing scheduled for the quick Delaney matter, which I think is June 24th at 1. So we
Yes, that
could-
is June
we could
24th.
do those, hear them separately, obviously, but the larger discussion may be beneficial to, especially for members of the public, too.
And I'll provide the memo that Lisa suggested before that.
Sure.
When do you like your packet by?
So if it's on, what day of the week is the 24th? Oh, it's a Monday? So if it's a Monday, I'd love to see it, I'd love to have the packet in hand by Wednesday before.
No problem.
So whatever date that is, 16th or something? Okay.
Madam Chair, if I could just
Sure.
ask a procedural question. I'm fine with the hearing staying open for additional submissions that may come in. My understanding, however, is that the next continued hearing, you wouldn't take additional public comment or testimony, or would you be looking for additional public comment and testimony? I just want to be prepared either way.
I think I'd be open for additional public comment in the event that something comes up, especially since we did hear that one of the brokers, was Ed Sanford, had submitted a letter. He wasn't able to attend today. He may want to speak. I think allowing for some
Madam Chairman,
public comment. Yes, Joe?
is there any way we could limit it to new
Sure.
information or new people talking?
Yeah, we could limit, we could.
Unless it's an urgent new
Yeah,
information, you know what I mean?
I get your concerns, I do. I just think this is such a personal issue for so many people, and I think that hearing, part of the thing is talking about that it's customary for Nantucket, and hearing people talk about the history, that it's generational. I get we don't need to hear like the whole story about every baptism and whatever, but it is important, and I think it was important for us to give people the opportunity to speak. So I don't think I wasn't planning on closing the public hearing, but I do think we should continue to that date. So
Okay.
Nina, if you're open to it and there's no strong objections, I don't see the harm in allowing public comment, as long as we're not rehashing the same things we went over today. I took a lot of notes on what everybody said.
Susan, I have a
Yeah.
question. It's going to be heard that day, but completely separately from the quick Delaney.
Yeah, they're two
application.
separate hearings,
Yeah.
but it just, instead of, it was hard enough for us to find some dates. I think if we could do both of them,
Madam Chair, for the record, I'm not.
you're not going to be here, but you can mull it in.
We'll be out of the country.
Yeah,
We'll see. Yeah.
you might want to consider, you'd continue the hearing that date. You'd continue, if you close then, you would schedule deliberations maybe subsequently.
Yeah.
With a draft decision, and then John would be able to weigh in. Does
Yeah.
it make sense to specify your voting members on this?
I think we have our, where did I put it? But we have our 5 regular members are here and sitting, so I think it'll be John Brescher, Michael O'Mara, Elisa Allen, Joe Marklinger, and myself. And obviously if something happens and someone can't mull it in or something happens, then we'll look to alternates, but we have the 5 voting members, so we should be
Great.
good on that. So I think the actual date that the next special meeting is scheduled is the June 24th at 1 PM. Is that correct?
Correct.
Correct. So that's what we would ask to continue to, if someone wants to make that motion. If we want to talk for half an hour, we can, but.
Or we could just choose to decide today.
Without any deliberation? I mean, well, we've asked, we could, but we've asked for, I mean, Lisa specifically asked for, I think, some valuable information. Nina also said she was going to provide us with some information about the corporate.
Yeah. Madam Chair, I'd appreciate the information that George will provide and whatever else.
Yeah, I think we could
Attorney Pickering-Cook
use some
will
And
provide.
guidance.
I just want to, I didn't mean to usurp the board. You certainly could close and just, take a
Yeah.
vote today. I didn't mean to
I
imply
don't,
that.
no, of course not. I
was-
don't think we're there
Yeah.
yet. But I also don't want to rush. And
I think
that's,
the record always benefits from keeping the hearing open, because then even if you have further questions, if you've closed the hearing, so I didn't mean to say that you're precluded from voting today. You certainly could.
yeah, but I don't see anybody really pushing for that. Yeah, Billy?
I just wanted to make a brief comment too. If we're continuing to the 24th, anyone that's here, that meeting will be upstairs above this room. So it's not, there's limited space this month on the room, so
Okay.
24th will be upstairs.
And it will also be available to anyone on Zoom as well?
Yeah, it'll be in a hybrid format.
Okay.
Madam Chair, I just
yes.
want to emphasize with this colloquy that I just listened to, that corporate membership, investment membership, that's not what's before you. It's the grapes using their property. They're not investors, they're not corporations. They used it between 90 and 111 days. That's the issue.
Okay, thank you. Thank you for bringing us back. Yes, Mr. O'Mara?
This application will be held first on the 24th?
Did you advertise the other one for?
Well, I mean, the meeting's at 1, so it's however the agenda ends up being drafted, so. I don't think we,
business versus old.
oh, yeah, right, new business versus old business, yeah,
So the old business would normally go first,
yeah,
That's right.
yeah.
but
I mean, we could also, we can decide that later. I mean, we've definitely made decisions with more information to move things around if we need to, so I don't know typically, yes, old business first, new business second, but if we decided it made sense to do it a different way, then we could, but, okay. Anyone want to make that motion? Okay, there you go, John.
I'll make a motion to continue the public hearing to June 24th at 1 PM.
I'll second it. Mike second.
I'm going to give Joe the second. Okay. So John Brusher made the motion, Joe Marklinger second, and I'll do a roll call vote. So John?
Aye.
Joe? Aye. Michael? Aye. Elisa?
Aye.
And myself, aye. Okay. All right, so we will see everyone back here on the 24th of June at 1 PM, either in person or via Zoom, upstairs if you're in person.
do we have to motion to adjourn?
And do we have anything else to talk about? Any other, nothing?
No, the only other item I had on there was the regular meeting on the 13th.
Yes, which is pretty jam-packed, so,
Yeah,
yeah.
we have 6, possibly 7, 6 items as of now.
And they're big ones.
Are we being kicked out at 4?
On
Here?
that time?
So is
On
that
the
noon or
13th.
1?
We have the room typically 1 to 4:30 on our normal meeting days, so we get kicked out at 4:30.
Okay. All right, so, and you, I know it's not, you brought that decision for people to sign. Okay, so, all right, so a motion to adjourn would be appropriate? Elisa makes that motion.
Second.
John seconds. I'll just do roll call again. John?
Aye.
Joe?
Aye.
Michael? Elisa? Myself, aye. Okay, that motion carries. We are